the meeting, the October 24th, 2015 meeting of the Special Magistrate Code Enforcement hearing to order. And what I'd like to do is take just a minute to go over the way that we'll run the meeting, just so that we're all on the same page. These hearings are evidentiary hearings, which means that you have the opportunity, both sides have the opportunity to present photographs or documents, as well as testimony into evidence. Please know that if you do present something into evidence, that it becomes a part of the record and it has to stay with the file. So be sure that if you want to show me something, that you're willing to leave it with me. The city has the burden of proof in these hearings, so the city will go first and present its testimony and evidence, and both sides have the opportunity to cross-examine one another in case you want to ask questions of one another. Then the respondent will have an opportunity to present any information that he or she would like to present. And I know nothing at all about anything that's gone on prior to this, so be sure to tell me everything that you want me to know. And then at the conclusion, I will make my findings. I'll let you know what I find, and then we'll reduce that down to a written order that will be mailed out to Pam, our specialist. So if there's anyone that's intending to testify today, if you would please stand and raise your right hand to be sworn in. Do you plan to?
I guess so, yeah.
Okay, could you stand? Just in case.
Come on, this is me.
Okay, right. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I will.
Thank you. All right, Mr. O'Rourke for the city.
Good morning, Your Honor. This is case CE 13-001627 regarding 885 North Division Street. My name is Sean O'Rourke. I'm the Code Enforcement Manager for the City of Oviedo. The violations are for Section 42-.1, which is encroachment, Section 1.5 of the Land Development Code, which is conformity with the Land Development Code, Section 3.4, development permits, building permits required, Section 4.14, structure setbacks, and Section 4.15, accessory structures. All statutory requirements for the notification of this hearing have been met. Supportive documents will be entered into the record as exhibits in chronological order. Your Honor, I will say that there are a couple of things that we will be bringing to your attention. And regarding the case, the purpose of the city moving forward and presenting is to get these items on the record. But again, I will address a statutory item at the end.
Okay, just for clarification as to the exhibits, I do have the exhibits that I believe were shown to the respondent. Is the city moving these into
Yes, Your Honor. The city would like to move all the exhibits into the record.
Would you like to move them in separately or as a composite exhibit?
As a compiled exhibit.
Okay, and then if you would, let me ask the respondent, do you have any objections to these documents that were given to you before being in evidence? Okay, great. Then they will so be accepted. Go ahead.
Thank you, Your Honor. Your Honor, the Code Enforcement Office was first approached back on August 7th of 2013. The zoning department received a survey from a buyer or seller, I'm not 100% sure which, that showed a garage encroachment into the right-of-way and asked if this was going to be a potential issue. The zoning tech stated they couldn't find any permit information and forwarded it to us. Actually, that email came from a potential buyer to the zoning tech. So the zoning tech forwarded it on to myself and the planning manager. I ended up speaking to the gentleman. His name was Mike Cousins. I spoke to the realtor, and the potential buyer was Mike Cousins. The realtor was Lori Kane. And what I told her was that, yes, those were definitely potential hiccups, that the structure in the right-of-way was definitely an issue, and that the city found no permits for the structure, and that the structure did not meet the city's requirements for an accessory structure. As far as size went, it didn't meet the setback requirements, so that there were issues on that property with regards to the survey that the buyer had provided to the city to ask about. So we discussed that within the staff. We contacted the city engineer to see what might be able to be done regarding the right-of-way issue, and I reported all of that back to Mr. Cousins in an email that outlined that the structure would have to be permitted, it would have to meet current setbacks, it would have to be relocated to the proper space. I discussed right-of-way accommodations. We discussed the fact that it was too large to be an accessory structure, that he would have to get a development agreement because it exceeded the deviations that were allowable by staff. So from there, we sent on August 8th a notice of violation to the property owner of record, stating that they needed to remove the structure from the right-of-way, not relocate the structure on property without obtaining a permit, and meet all applicable setbacks. That notice of violation was signed for and received. On September 3rd, an attorney, Grace Glavin, called us and asked if there was a permit for the structure when it was built. I actually spoke to her, told her that we did not find a permit for the structure. And during the course from August 7th, when this was brought to code enforcement's attention, until we sent the notice of violation, the property changed hands. We had a different buyer bought. So we had sent our notice of hearing to the owner of record at the time, Mr. and Mrs. Muse, William and Virginia Muse. But as I stated, the property changed hands, and I believe I have the certificate of title. The property changed hands in September to James Lehman and Shannon Miller Lehman. The reason the city is going forward, Your Honor, is that you have a copy of the warranty deed that was recorded on September 30th of 2013. The reason that the city is going forward is because we wanted to have in the record Florida Statute 16206, Enforcement Procedure, subsection 5, A through D. That should be attached to the very first. Okay. 16206, subsection 5. Subsection 5 says if the owner of property that is subject to an enforcement proceeding before an enforcement board, special magistrate, or court transfers ownership of such property between the time the initial pleading was served and the time of the hearing, such owner shall, A, disclose in writing the existence and nature of the proceeding to the prospective transferee, deliver to the prospective transferee a copy of the pleadings, notices, and other materials relating to the code enforcement proceedings received by the transferor, disclose in writing to the prospective transferee that the new owner will be responsible for compliance with the applicable code and with orders issued in the code enforcement proceeding, and then D, file a notice with the code enforcement official of the transfer of the property with the identity and address of the new owner and copies of the disclosures made to the new owner within 5 days after the transfer. The failure to make disclosures described in paragraphs A, B, and C before the transfer creates a rebuttable presumption of fraud. If the property is transferred before the hearing, the proceeding shall not be dismissed, but the new owner shall be provided a reasonable period of time to correct the violation before the hearing is held. Your Honor, the city's position is that the notice of violation is the charging instrument for this case, and that it would fall within subsection 5 being subject to enforcement proceedings. Further down in A, B, and C, it references the notices and other materials specifically in B. So we feel that the notice of violation did warrant did meet the criteria of subsection 5 that the property was subject to an enforcement proceeding. We also fully recognize that the new owner shall be provided a reasonable period of time to correct the violation, and we absolutely are going to do that. But we did want it entered, or did want the city's position made known that we do feel that this section of the statute does apply to this case, and that there was proper notice given to the ownership at the time. I don't know whether that owner transferred that information to the new property owner or not, but rather than dismiss the case and start from scratch, we felt it was important to follow the statute and not dismiss the case, but now provide the new owner with an opportunity to resolve the matter. And we'll certainly work with the new owner to do that.
You went right to what I was going to focus on, which is the new owner having reasonable time.
Absolutely.
If you could go over the dates with me. I know you said August 7th was when you were initially alerted to it.
Correct.
By a potential buyer, and you spoke with that buyer.
Did not end up purchasing the property.
Okay, so that is almost no notice at all to the property owner, because this is just a potential buyer who doesn't end up buying. So August 7th is not our start date.
No,
When is our start date where the previous owner
we sent the notice of violation on, I believe it was October 8th. I mean August. I don't know why I said October. This is October. On August 9th. August 9th of 2013 is when we sent the notice of violation. And that was signed for and received on August 9th. And you have those you have those in your packet. And then the warranty deed was recorded on August 30th. The deed was made the 24th day of September and recorded on September 30th. It wasn't until we prepared for this hearing that we found the new property owner and the property appraiser records. What the city has now is a three-tiered, actually a four-tiered system of deviations. From 0 to 10% can be done at the staff level. From 10% to 20% can be done at the DRC level. Up to 30% is DRC and PZA, and then anything over a 30% deviation must go to council and becomes a development agreement. So this would be more than a 30% deviation. It would require a development agreement with council, and then you also have the right-of-way issue, which that would be up to the city engineer as to whether he could work something out about the encroachment. And since the original buyer who called us, did not follow through and pursue, the city engineer has really not rendered an opinion as to what he would do, because that prospective owner, at least to my knowledge, did not pursue the event with the city engineer. So I don't know what he would do for the new owner. That's something he would have to work out.
Is the city asking the magistrate today to find that these violations exist?
We would like, yes, we would ask that you find that the violation does exist, and that we move forward with giving the new owner time to correct, and that's going to probably be a somewhat lengthy time, because they're going to have to explore a number of different options. I'm thinking 60 days would probably...
I'm thinking at least 60 days too. This
Yes.
is like a big project.
Yes.
If I were to find, and I haven't
Right.
even looked at the,
And I don't know if we would want to include something where the new owner comes back to the board, I mean to the magistrate, to your honor. I mean, we fully intend to give the new owner every opportunity to explore every option they have and make a decision as to what will be their most prudent step to resolve the matter. And there are more than one option, and it will involve more than one department. So 60 days was definitely what we believe to be at least a starting point. But if you look at the survey, we do have an encroachment. We don't have a permit. The accessory structure is larger than what would be allowed. The location is not to the rear of the house, which is required. The setbacks for that size are the building setbacks. An accessory structure has much less of a setback, 5 feet rear, 5 feet side. If it's larger than 120 square feet of floor space, it has to meet the building setback, which would be whatever the rear building setback and the side setbacks are for that subdivision, probably in the neighborhood of 20 to 25 feet for the rear, and probably 12 and a half feet from the side, because it's on a side lot. Those are all things zoning would go over with them and research and determine. But the structure as it is would never be permitted in its current location, at its current size.
and I do want to talk about each individual
Sure.
issue, and I know you just hit on them, but I'll tell you where I'm getting held up.
Okay.
On 16206, subsection 5, if you, and I know you have this in your packet, I'm speaking to the respondent, if you want to read. Okay, can we provide copies? Okay, that's in the packets. It is actually, if you see there's a letter dated October 23rd, that's what I'm referring to.
Oh, yes, I forgot to
You actually
bring
printed-
that up. Yes.
You printed that statute, and I want to give the respondent time to find the letter that I'm talking about, but it's...
Yes, I failed to mention, Your Honor, that once we discovered this, that on October 23rd, we did send the new property owner a letter advising them and did spell out the statute. Yes, you're correct. I forgot to mention that.
No, I think that was really helpful. I just want to make sure he's able to follow.
And again, what we asked them is to schedule a meeting with us, with me, so I could lay out
Right.
everything they'll need to do
Right.
to get started.
What I want to draw your attention to, because this is where
Okay.
this is what I can't get past, is in this 16206, subsection 5, after D, there's the paragraph that discusses the failure to disclose. Described in these paragraphs creates a rebuttable presumption of fraud. If the property is transferred before the hearing, the proceeding shall not be dismissed, but the new owner shall be provided a reasonable period of time to correct the violation before the hearing is held. And so the before the hearing is held is where I'm getting hung up. Because if the hearing is for me to find whether or not there's a violation, it seems as though the reasonable amount of time should fall prior to the finding of fact as to whether or not I agree. I read this the same way that you have stated, although I do want to hear from the respondent. But I think that last sentence is my biggest concern, that we're having a hearing today and the notice to the new owner was provided.
We actually haven't cited the new owner. We've only sent them a letter, just a informal letter to advise them that there is a situation. We have not sent formal notice to the new owner.
Okay.
So.
And the day of the letter, is this the October 23rd?
October 23rd letter.
Okay, so
That's informational for them. We felt that with it coming to a hearing that we wanted to, and this is when we found out that there was a change of ownership that we didn't want to delay.
Right.
But yes, we have not formally cited the new owners. So I understand
that responsibility was not on the city. But my concern is that we're dealing with a letter that went out yesterday to new owners, and the statute says that a reasonable amount of time has to be provided before the hearing is held. So that's where I am. If you have anything else to
Well,
offer.
the only thing that I would say is that we haven't formally cited the new owner, that the purpose of coming forward with the hearing is really to get on the record that the burden is on the previous owner to have notified the current owner of the proceedings.
Right.
And if that would have occurred, we would have already engaged the new owner, and we would not be here because we would have given the new owner a time to comply. I think our purpose is to get 16206 subsection 5 A through B on the record.
Okay.
To show that the burden was on the prior owner, since they had been noticed of the violations, to convey to the new owner.
But can't we get that on the record without
I
having
believe,
to have a finding on each of the
yes,
violations?
yes.
So perhaps that's...
Yeah, that was the primary objective of the hearing today.
Okay.
And again, if the new owner responds to our letter, we may never cite them.
Right.
We might just work through the process with them.
Right.
If they don't, then yes, we would initiate a formal notice of violation, and we would go through the whole process and give them a reasonable time to correct. And if they didn't, we could end up back here with the new owners. But our intention with the letter was simply to start the dialogue to get it corrected, not cite them right now because we felt they didn't know.
Right.
And just also, like I said, we wanted to let them know that it wasn't our burden
Right.
to do this. It was the burden of the prior owner. We'll work with them now.
Okay. Does the city have anything else?
No, ma'am.
All right. I'd be happy to hear from the respondents. Or
Thank you.
if you would please, sir, step to the podium and state your name for the record.
Oh, it's William Muse, M-U-S-E. I had these handouts to give to you to let you know with the history of what had happened with the house.
Okay.
When I bought it. The shed was already there, so I inherited the problem. And when I signed on the house, I noticed in signing, I says, what's going on here? What's this right-of-way issue? And they said, don't worry about it. When the city needs to widen the road, then you can take care of it. And I'm thinking, I've been in Oviedo 16, 17 years, volunteered for the city. The city doesn't move very quickly. So I said, okay, no problem. Well, what happened was in March of this year, I lost my job with Cubic. I was let go for reduction in force. So I could no longer make the house payments, so I had to put the house on the market, and I used Lori Kane because she got me the house in the first time. So a couple of months went by, and there was no response other than, dribs and drabs is not what I expected. So I terminated her employment and got another realtor. Well, that's the time when I got the violation notice. So since I'm living in Jacksonville now, I delegated it all to my new realtor, said, here, take care of this. Well, as you can see, he didn't take care of it, and I'm here. But I want to let you know that the new owners do know of the problem. When we made an addendum to the signing, that they are aware that I will take full responsibility for it, even though I didn't put the thing up there. So that's my only concern, and that's my wife's concern. She'd be here, but she's with her mom with chemo. So I would just like to, work with the city, because I know how the city is, and I want to make things right. That's the only thing.
So you are you have sold it, but any kind of contractual agreement that you have with the new buyer wouldn't be an issue before me or for the city.
Right.
You wouldn't get involved.
Right, but they're aware of what's going on.
Right.
So.
My biggest concern today is just that they have notice of any hearings that we have. So I appreciate you giving me the history on it.
Right.
But because you've sold it, it wouldn't be, the burden on us is not to give notice to you because you've sold it. Our burden is to make sure that the new owner has notice.
Now, will they get more help than I did? Because all I got was a notice saying, hey, you need to take care of this. Now, that was my fault, too, not calling Sean and say, hey, how can I deal with this? But, maybe the new owners will work better, we'll get more help than I did. Because it's hard being up there.
I think that they're generally very helpful. So I would encourage them to just make the phone call. But I appreciate, since you're the past owner, it's not really...
well, I feel responsible for it, even though I got stuck with it.
Yeah.
And I'm afraid that if I don't put the bill, I'm going to get sued. And I don't want that, and they don't want that.
Right.
So,
Right.
but...
Okay. Is there anything you want to show me, or...
No, not really. I was going to show you the way that the modifications to the shed, but after hearing what Sean said, it's, I don't know if it's even feasible to do that. So,
Right.
well,
And I don't have to...
that's not your call.
You're welcome to show me anything. I want you to make sure that you feel like you've told me everything you wanted to tell me. I'm happy to look at anything.
Okay. They'll give one to him, too?
If you have.
I made copies.
But anything you give to me, then that's mine.
Okay,
So
you can have it.
It stays in the record,
That's
so
all right.
make sure. Thank you.
Okay. You can kind of glance through there. It tells you about the history, the problem, the solutions. But after hearing what Sean said, you can't move it. There's other problems with it. I contracted a general contractor to make the modifications, whom I heard from just yesterday wanting to see the violation. So I don't know what's going on with him, even though I've paid him. And on the second sheet is the modification to the wall based on the amount of right-of-way issue. It comes out on the survey. It says it's 0.8 feet, which equals out to 9 5/8 inches into the back, which goes into the alleyway onto the street. So my suggestion would be to rotate the wall 3 degrees, thus bringing the wall back a foot, which will passes the 9-inch or 9-inch right-of-way issue.
Okay, so, Mr. O'Rourke, these would probably be helpful with the engineering department, or?
Yes, Your Honor, and just so Mr. Hughes knows, this is a reasonable starting point.
Right.
And the city can address all of these.
Right.
It might take more meetings and more money than you wish to spend.
Well, I just want to get it right.
Right, but this is a reasonable starting place.
Right.
It may not be the end result, but it will
Right.
be one of the options. So
glad you gave this to us. This
You
is
glad you did it?
Yes.
Kudos for me.
All right. Is there anything else you want to tell me?
No, have a great day.
You?
I'm going next door. Am I through?
You are. Thank you.
Okay,
Oh,
I'm
tell
going
you
to
what
sit
I'm
around and see what you decide.
I'm going to tell you right now.
Okay, do I stand or sit?
Whichever you like. You can probably.
I'll go sit.
Because I'm going to ask the city to come back up if I could, Mr. O'Rourke. Would the city have any objection to the entry of an order that this proceeding began with notice, rather than a finding of violation?
Okay.
That the proceeding began, August 9th with the notice to the former owner, and that it's proceeded, but there was, and a notice will go out for a hearing to the new owner, and we can do that at the next hearing?
The only thing I would say is if the new owner comes in and initiates a process to resolve this, normally we wouldn't cite them while they're working with the city. It would only be if they stopped and failed to move forward with any kind of corrective action.
But the purpose of the hearing, from the city's point of view, is to just get it on the record that the alleged violation was noticed back in August.
That's true, and then to also make sure that the new owner knew where the responsibilities lie, which Mr. Muse testified today, and by his document that he provided, they obviously do know, and they obviously are prepared to go forward. So
I'm not comfortable accepting, I can take hearsay on a lot of issues.
Okay, right.
But as to formal notice of a violation to an owner, I'm a little bit more, I want to be a little bit tighter with that. I'd like to see a green card with
Right.
it signed, something like that. So I'm happy to say I think we all agree that the former owner was noticed, and that carries forward to the new owner, and the responsibility is not on the part of the city to notify the new owner. But before a hearing for a finding of the violation, I would prefer the new owner actually have due process.
understood.
So are we all comfortable with an order just saying that the violation began in August and the former owner was notified?
Yes.
And we won't set it for the December 11th hearing because it may.
Correct.
It's like we're all moving in the right direction.
Correct.
So, okay.
That would be very
That would be my preference. So that's what
amenable
we'll do.
to the city.
We'll just enter an order saying that this began back in August and we're working on it. Okay, so that'll be my order, and you'll get it, I'll send you a copy of that too. Do we have your new address, Mr. Muse? We do? Oh, yeah. Okay. Do, Pam? Okay. All right, then we're all set. Thank you. Thanks for being here today. Sorry, I want to make sure
Yeah, no problem.
when I sit down to type the order, I need to make sure I remember exactly what I said. Okay. Moving on. How you doing? Your throat all right?
Yes. Your Honor, we do have the respondents for the second Massey hearing here, so would you like to hear that first?
Absolutely.
All right. Again, my name is Sean O'Rourke. I am the Code Enforcement Manager for the City of Oviedo. This is case CE 13-001833 regarding 590 Geneva Drive, Oviedo, Florida. Your Honor heard this case on September 26 of 2013, And I would like to point to Your Honor's order, and specifically on the second page under the finding of fact and conclusion of law, the first paragraph states that the following violation was found to exist on the subject property: the commencement of an additional commercial use of the property without an appropriate development order pursuant to Section 1.5 and Section 3.3 of the city's Land Development Code.
Right.
The order at the time was that the respondent should have until midnight, October 23rd, to meet with officials of the city, and that the respondent would comply, and then a second hearing would be held today. The respondent did meet with the planning manager, myself, and the development review specialist yesterday at a pre-application meeting. Everything was explained and discussed, and the planning manager and myself obviously support Your Honor's order that a development agreement or a site development order must be had in order for them to conduct a U-Haul business. The respondent kept referring back to the number of 4, which I believe by the end of the meeting yesterday we had finally made them understand that there is no 4, that the business itself has to be, they either have to not have the business, or if they have the business, they have to go through the site development order process. So they did comply with meeting the, with having the meeting. And I think what we need to address now is the time frame for them to either apply for the site development order or to cease the operation of the business. If they're going to apply for the order, the city, obviously, it's a reasonably complicated process. They're going to have an engineer. They're going to have plans. There's a whole process once they submit. There's monies, substantial amount of monies in the $5,000 range just to submit. So that time frame would have to be fairly extensive, somewhere in the neighborhood of probably 60 days. But if they're not going to pay the application fee and submit, then it's the city's feeling that Your Honor has already stated that the use is not in compliance with the code, and we would ask for a shorter time to cease the operation of the U-Haul business. And that's something that the city would be willing to hear from the respondent as to how much time, and I think it has to be obviously less than the 60 days that it would take, because ceasing the business operation there is certainly a lot simpler than going through the process that it will take to get a site development order. There is one other complication with the site development order, in that the property is non-conforming.
Right.
So to increase the non-conformity removes the non-conformity, and from a practical sense, I'm not sure that that would be the course of action that would be best for the respondent. So just simply applying and going through the process of trying to get a special exception use order, a site development order, is then going to trigger the nonconformity, which is a completely separate issue. Your one is defeating the other. So,
you know what? And I keep going back to this, but the issue that I'm always the most concerned with is notice, because it's due process. It's like the most basic. And the order said that they had to meet with you by October 23rd, and if they didn't, then we'll be here today, and we will only talk about compliance. And so compliance, I think, can be read as complying with the order to meet with you by October 23rd. Then
Agreed.
My concern is that as they sit here today, they didn't know that we were going to be discussing, they don't have notice that we're going to be discussing how long they have to do these issues. So I think that unfortunately, I think that we'd have to give them notice that, to come in and be prepared to discuss how long you need. Because this order, although I remember we went through all of this, I'm very
Right.
familiar with this, with how we got there and the 4 trucks and all of that. But my concern is that this order that I entered can be read that I'm ordering that you have to meet with the city before October 23rd. And if you don't, we have a hearing on October 24th. And the only issue we're going to talk about is whether or not you did what I ordered you to do. So I don't.
And it may or may not be appropriate to ask, Your Honor, but the city is of the opinion that they have been found in violation. So they're currently in violation of the city's code.
We just don't,
So-
there's no order that exists that.
Then we would renotice them with a notice of violation?
I think
That
the
seems
violation, I
redundant.
renotice that they would be on notice that the issue of the hearing would be the penalty that would be assessed for their failure to make it a conforming, or to remove the violation. The violation exists, the order is entered that the violation exists, but I think a property owner would need to be on notice that the hearing, the issue would be, because at that point we would be assigning, what the penalty would be after 60 days or whatever it was.
So would that come from the court or from the city? Would
Well,
the city have
would
to?
notice another hearing. That's where I am on that, and I want to hear from the respondent.
Okay.
And I'm not prejudging, I'm just telling you, my
Okay.
concern is that the way that I wrote this order, and that's on me, I ordered them to meet with you by the 23rd, and they've complied with that. So my concern is entering a new order when they've only had 1 day notice, that we may be talking about penalties and fines and.
Would the court be able to establish those timeframes today? Or is that something I should ask after we hear from them?
Why don't we, I would be concerned about it, but I'm anxious to hear from the respondent. And if you could, who is it that's going to testify? You're going to translate? Okay. Okay, great. Could you both please stand and raise your right hand to be sworn in? Thank you. If you raise your right hand, please. Raise your right hand. Do you swear or affirm that the testimony you shall give shall be the truth and nothing but the truth? So help you God? Yes, both? Okay. State your name, please.
ممدوح يوسف last name يوسف
Okay. And you are the owner of the property?
it's owner it's manager I'm sorry
Manager. And the owner has sent you as his representative today?
الأونر يعني بعتك النهارده إن أنت تتكلم بداله يعني.
no
He's renting the store, so like he's and owner.
Okay. Does the owner know that you're here today?
not in here today
هو الأونر عارف إن أنت النهارده؟ No.
Does our notice go to the property owner? At the property address, and that's listed on the property appraiser's site? Okay. Go ahead. Tell me anything you want me to know.
He was asking about
كلنا هنقول على الابلكيشن بتاع امبارح هم بعتوا لنا الابلكيشن امبارح طب ماشي ما انت تقولي لها وقولي لها نقول النهارده ان احنا عايزين
يعني
نشيل
طبعا
لا بعد ما نخلص الموضوع ده بعد ما تقولي الكلام ده
okay, he's saying that we're here today for saying we're not gonna do the application, the application for filling the process. So we're just gonna stop the business for them today.
Okay. So you've decided to stop the additional business of the U-Haul rentals? You're not going to perform that?
Until
commercial-
قررت إن أنت ما
اه
تعملش.
ما كانش
Yes.
Okay. Okay. That's good to know. All right. Is there anything else you want to let me know?
Yeah, he was wondering, he just paid the $200 for the U-Haul, so what's gonna happen with that?
No. I wish I knew. What we can do is, before you leave, we'll find out who can tell you the answer to
Okay.
that. Okay.
يعني قبل ما نمشي
I'm sorry, I just don't know.
هيعمل
I'll ask the city when they come back. Thank you. Mr. O'Rourke?
Yes, Your Honor.
So, sounds like we need another meeting, or?
Can we ask the respondent when they plan on ceasing the
Sure, you
use?
all-
Because if they offer a date that's reasonable, I can accept that.
When, hey, Monica, if I could, when is it that you plan to stop having the U-Haul on the property? 15 days? Okay, what's the position of the city at this point?
15 days is totally reasonable. I mean, if you want to give them up until the day before the next hearing, I don't know if we want to, although it sounds like we're not going to tie that date into the next hearing, so 15 days is more than reasonable for me. 15 days is
I'm
acceptable.
still stuck on notice, so
Okay.
I am very hesitant to order them, to give them 15 days or to
Okay.
give them, to enter an order with a substantive
Okay.
directive like that, because I just don't think that they got notice.
Well, then,
But an agreement
we'll-
is encouraged. So, I mean, if,
would you be willing to enter into a written agreement with the city about the 15 days that both of us would sign off on? We can handle that outside the court?
you don't need me at all.
Okay.
I've written, that's not good for job security. Yeah.
Anything else?
No, if that's great. Thank you. Thank you for being here today. Then I will not be entering any order on this. Thank you for, what did it say, the saying, blessed are those that can agree, or, so I'm going to give you this one. Last one.
Okay. Once again, my name's Sean O'Rourke. I'm the Code Enforcement Manager for the City of Oviedo. This is a Massey hearing for case CE 13-001554 regarding 331 Reed Avenue. Your Honor heard this case on September 26, 2013 for open storage violations. Your Honor ordered that the respondent had until midnight, October 23rd, to bring the property into compliance. And I re-inspected the property today, and it is satisfactorily in compliance with the city's codes. So they have met the burden of your order and are in compliance at this time.
Great. So you need nothing from me?
Correct.